All right. Good morning, everybody. Welcome. And we look forward to our session with Dan today. And just want to welcome all of you and look forward to putting this all together. Dan, we're going to turn it over to you. Before I do that, I just want to lead us in prayer this morning.
Sure.
Father, thank you for your goodness to us. We thank you that in these days, you are so watch care over us in so many ways. And we just thank you for that. We thank you for families. We thank you for friends. We thank you for neighbors, and we thank you for the chance to learn this morning more about what you have done in our country and how important it is for us to know the truth about your relationship with us and what our country has come from. And so we just thank you for this morning. And as we give it to Dan, we ask that you would bless him and keep him straight in all of his thinking so he can share it with us today. In Jesus' name, amen.
All right, thanks, Dave, and welcome everybody to I think this is our fourth class now on the Christian history of America, the background of our cultural history in the United States, and of course we've got into this because of the crossroads that we're at here in America. So I've circulated the outline here, the note-taking outline entitled "The Nature of Law." So if you want to take out your note-taking outline, we'll get right into this. We're going to talk about the legal structure, or more accurately, the system of law under which the United States was originally set up to operate. And so we're going to compare that with what is going on today. And I think that's going to answer a lot of questions as to how America has gotten so far away from its original plan as a nation based on God's laws. The great Roman statesman and Roman lawyer Marcus Tullius Cicero was one of the leading opponents of the consolidation of power in the hands of Julius Caesar at the time the Republic was collapsing. Cicero was a very, very strong, ardent advocate of the Roman Republic, the system of law that Rome was established under in 700 BC, 750 BC or so, when they became this leading republic in the era. The Republic was collapsing around, beginning around 150 BC, and it finally collapsed when Julius Caesar declared himself dictator for life and deified himself, declared himself a god, which is kind of cool, I guess, if you can declare yourself a god and make it work. That might be kind of cool, but of course he didn't have the actual power to do that. But Cicero was a strong opponent of the consolidation of that power, and Cicero wrote a book called De Legibus, which means of the law, and it was a discussion by Cicero of what the nature of law was supposed to be. And Cicero describes the primary purpose of law quite simply. He says the law ought to be a reformer of vice and an incentive to virtue. The purpose of law is to restrain immorality and to maintain social order. That's what it's all about. It's about commanding us to do things that are good and forbidding to do things that are bad. It's the distinction between just and unjust, and it's consistent with the concept of that Paul expresses in Romans chapter 13, where he says the civil magistrate wields the power of the sword. He wields the power of force for the purposes of good and not evil. And this is consistent with Cicero's observation of what the law is to be as well. A reformer of vice, that is to say, to suppress that which is evil, and an incentive to virtue to do that which is good. And so legal systems of all governments are based on some religious concept. And this is true across the board. They say that law and religion are twin sisters, all right? They operate together, and we see this. There's no more clear example of that than the religion and the legal system of Islam. Islam is a religion for sure, but it's also a system of law. And it's we're not going to get into the differences between Islam and constitutional law, but they are remarkably different in every respect. And so what happens is religion, the reason religion and law are twin sisters is because religious principles inform our personal morals and our value system. That's what it does. It dictates how we raise our kids, how we interact with our family, how we interact with friends, how we do our jobs, how we interact with people that work with us, how we treat coworkers. Our religious principles shape our social standards. Do we believe in life or don't we? It dictates the nature of government. Is the government going to be a totalitarian system of force imposed by one person or one group of elites upon the whole rest of society, or is we going to have a system where people are free to pursue life, liberty, and property? All right, that's where this religious influence on law comes from. And in fact, we talked about this in our first session when I talked about Alexis de Tocqueville and his book, Democracy in America, which was written after he toured America for about a year. And he wrote about his observations and how Americans embraced the Christian culture in every aspect of their life. All right. And so this is how religion informs the law, and it does it across the board, regardless of what kind of legal system you have. It's informed by religion at some level. Now, it ultimately, friends, at its very basic level, at its very foundational level, there are only three types of governments that have ever existed. There's variations of these, but underneath this umbrella, but the umbrella encompasses just three types of governments. The first one on the list is a republic. All right, under a republic, you've got a fixed system of law, and people control the power of government. Now, to the extent that people control the power of government, they do that through their votes. And this voting process imparts some level of democracy. And we're going to talk about that. But a Republican government is based on a fixed system of law where the people control the government. Then we got a monarchy. A monarchy is a fixed system of law as well. The problem is the prince controls the power of government. And to a great extent, the prince dictates what the law should be. All right, monarchs are hereditary. That is to say, the next born of the monarch assumes the power of government, and the people don't have any authority in dictating who their rulers are going to be. And then the third system of government is a despotism, and that is to say, where there's no fixed system of law, where the tyrant, one person, controls all of the power of government, controls all of the power to make the laws, controls all of the power to dictate the principles of property ownership and so on. So under a dictatorship, there is generally speaking no ownership or under a despotism, there's generally speaking no ownership of private property. That can vary. As I said, there's variants of this stuff, but generally speaking, there's only three of them. And so we're going to dig into that. Now, the Declaration of Independence, in the Declaration of Independence, Thomas Jefferson accused King George of taking steps that would lead to absolute despotism, and he called him a tyrant. All right, so this is what was driving the revolutionary spirit, if you will, the spirit of independence, more accurately, during this period in the 18th century, was this idea that King George was assuming the mantle of a tyrant, establishing despotism on the people of the colonies, and that's, so that's what drove him. So religion and morality established the central principles upon which government is based. And what religion and what rules of morality are going to dictate, that becomes the question. But General Washington, President George Washington, made this crystal clear in a statement that he made in 1796 as he was leaving public life at that point in time. He says, of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. In vain it would be that man should claim the tribute of patriotism, who should labor to subvert these great pillars of human happiness. The mere politician ought to respect and cherish them. A volume could not trace all their connections with private and public felicity, that is to say, happiness. All right, and let it simply be asked, where is the security for property, for reputation, for life, if the sense of religious obligation is absent? And let us with caution indulge the supposition that morality can be maintained without religion. whatever may be concerned to the influence and refined education on minds, reason and experience both forbid us to expect that national morality can prevail in the exclusion of religious principles. And so it is a simple fact of life that religion dictates our morality, and the question is what religion is going to do that. Now, historically, the law of the American colonies and the early American states, right up through the mid 20th century, America stood firm against these types of immoral actions that we call criminal acts, like murder, theft, arson, perjury, kidnapping, and then things that go more toward the moral side, adultery, incest, rape, of course, abortion, infanticide. All of these things were laws under the were crimes under the American law, and well, they should be, because you might think that these are common beliefs that are the common characteristics that are believed in all cultures, but in fact that would not necessarily be the case. Now, when we talk about these crimes of murder and theft and arson and kidnapping and these types of things, we've all heard the expression that says ignorance of the law is no excuse. Show of hands, everybody's heard that expression, ignorance of the law is no excuse. But this idea of ignorance of the law only applies to a certain type of law. All right, in Latin we refer to this as an act that is malum ense. The Latin phrase is malum ense. That's M-A-L-U-M. There's three words, E-N-S-E, malum ense. And what that means is a Latin phrase that means that this act is wrong in and of itself. It's wrong from a moral standpoint. So when you say ignorance of the law is no excuse, what we're talking about is murder and robbery and these types of things. It's not a legal defense to say to the judge, well, judge, I didn't know I couldn't knock off the liquor store because there wasn't a sign on the door that said no robberies allowed. That's not a defense. All right, people are presumed to know the law when we're talking about these laws that offend fundamental moral principles, rape and murder and these various things. All right, but there's a second type of action that is deemed wrong when civil society organizes and starts to pass laws, and those laws are called malum prohibitum, and it's M-A-L-U-M Prohibiton, malum prohibitum, and that's a Latin phrase that means that it's wrong only because someone says it's wrong, as in a legislature. It's not immoral per se, it's wrong because the legislature says it's wrong. This is malum prohibitum, all right? And this is an act, for example, driving 70 miles an hour on the freeway when the speed limit is 60 miles an hour. That's not a violation of any moral code anyplace. It's a violation of law because the legislature said you can't go 70 when the speed limit says 50, all right? So this is a malum prohibitum offense. The presumption of knowing the law applies to these moral, these inherently immoral actions like murder, rape, and so on. And this is the system under which the American law was based, and most laws were based. Now, as I said, you'd say that these are the basic beliefs of every culture, but are they? Is that true? You know, Rome, and let's get back to Rome for a second, had a very advanced system of law. And in fact, they were the first government to have free elections and open elections and the ability of people to choose their senators and their senators and so forth. They had a judicial system that protected certain rights. And our American founders studied Cato and Cicero at length, and the jurists during the latter years of the Roman Republic were sound applicants of moral law. But what changed? What changed after the fall of the Republic when Julius Caesar took charge in basically 46 BC? Virtually all of the practices that we call immoral today were common in Rome because their moral system changed. Rome was ruled by increasingly brutal dictators. All right, from Julius Caesar went to Augustus, Caligula, Claudius, Nero, Otho, Vespasian, all of these people were increasingly immoral leaders that usurped law and created total chaos in Rome and all of these, and the totality of the Roman Republic fell along with it. So the question is, what is the source of religion and morality that shaped America's national conscience? Why did we stand against these things like murder and theft and homosexuality and infanticide and these various things? And the answer, the short answer, and we're gonna drill into this more deeply as we go here. The short answer is that God's law, as expressed in the Old Testament, is what shaped the legal system of the United States. It was, and we talked about this last time when we talked about the sources of authority that the founders relied on to support their positions that were expressed in their letters and their pamphlets and their articles and so on. There were a number of authorities that the founders relied on, but the Bible was the single #1 most cited authority in this founding era. 34% of all of the statements of authority that the writers used, whether they were writing a book or a pamphlet or a newsletter article, a newspaper article or whatever, the Bible formed 34% of all of their authority for these positions. All right, so it is what drove their thinking. All right, so and the founders studied law and government extensively. All right, they were deeply drilled into these concepts. They knew what they were talking about. This quote from John Adams really tells exactly what was going on as far as his perspective, but you could say this practically across the board of the leaders during the founding era. He says, "The science of government is my duty to study more than all other sciences. The arts of legislation and administration and negotiation ought to take the place of, indeed to exclude in a manner, all other arts." And why is he doing that? He says, "I must study politics and war, that my sons have liberty to study mathematics and philosophy. My sons ought to study mathematics and philosophy, geography, natural history, and naval architecture, navigation, commerce, and so on, in order to give their children a right to study painting, poetry, music, architecture, statuary, so on and so forth." So Adams is saying, we've got to know what system of law our government functions under. We've got to understand these things intuitively and innately so that we can so what's the purpose? To bring peace to society. This is the thing that's driving the thinking, friends, is bringing peace to society, bringing an ordered culture that's established on some sound foundation of law so that one generation after another can have the blessings of prosperity that comes with a stable society. All right, so this is what they were doing. They were studying these systems. And there were 3 writers that had a profound effect on the thinking of the founders. We talked about 2 of them already, and I'm going to get back to those 2, and maybe you remember who they were, but I'll remind you here as we go forward. But one of the writers, and I don't have in this scorecard, so to speak, as to the sources that were relied on, was developed by historian David Barton. And he's actually got a scorecard that he produced based on studying 15,000 different writings that were produced during the founding era. And by writings, we're talking about letters and books and newspaper articles and pamphlets and so on. And what was the source of authority that these writers were using? Well, we know that 34% of them, #1 on the list was the Bible. That was the single biggest source of authority. But there were 3 individuals that they relied on extensively as well. We talked about 2 of them, and we're going to get back into that. But the third one is a guy named Montesquieu, Charles D. Montesquieu. He was a French jurist and philosopher. In 1748, he wrote a book called The Spirit of Laws, where Montesquieu lays out the different types of government: republican form of government, a monarchical form of government, a despotic form of government. He breaks down the system of laws that function under each and every one of these things. And Montesquieu talks about what is necessary, what kind of a legal system is necessary to establish the most amount of social order with the least amount of government invasion, this balancing test, if you will, between allowing freedom to the fullest extent possible without reaching the point of anarchy. Now, anarchy doesn't mean chaos. Anarchy leads to chaos in many occasions, but it doesn't mean chaos. We often confuse those terms, anarchy and chaos. Anarchy simply means lack of government. That's all it means. Right? There is no formal government in operation at any level. Every person is on their own to fend for themselves. That's what anarchy is. And that's on one side of the spectrum. The opposite side of the spectrum is totalitarianism, where there's no freedom whatsoever, that the government, whether it's an individual tyrant or a panel of hierarchy of some kind, 6, 8, 10 people, 20 people, doesn't matter how many, but to the extent that there's no liberty in society, that's where we've got a tyrannical form of government. So those are the two opposites. And Montesquieu talked about this balancing test and how you strike that balancing test in society. He talked about the need of society to be built on principles that do not change. This is Montesquieu talking. The principles of law upon which a society is built cannot change. They have to be stable. He talked about the difference between what you might call an evolutionary type legal system that moves and changes and floats around versus something that's stable. And of course, this Darwinian philosophy is the one that suggests that things move around. We'll get to that. We'll talk about that. But Montesquieu addressed that head on, not Darwin, because Darwin didn't live at this time, but he talked about this evolutionary type approach to the legal system. He says it's absurd to believe in random chance when it comes to this theory of evolution, this blind fatality, or to say that fate alone has control of life. He says fate can't create intelligent beings. Therefore there is a creator. And he says God created the universe. And he says God's laws control the universe. God acts according to his rules. God made the rules. God knows the rules. He knows how they interact. And these rules reflect his wisdom and his power. This is Montesquieu talking now. He says God's laws are invariable. These laws are, this is a quote, these laws are fixed and invariable in relation to man. Without them, the world would disintegrate. As a creation of God, now here's where he talks about man's relationship with God and the laws of God. He says that as a creation of God, man is subject to God's laws. Man has free will. There's no question about that. We'll talk about this free will thing in a minute. Man has free will, and he is subject to ignorance, and he's subject to error. Of course, God is infallible, but man is not infallible. And man is subject to free will. So in order to remind man of his duties to God, God provided the law of religion. And in order to remind man of his duties to fellow man, then God provided the law of morality. And this is Montesquieu explaining the relationship between God's laws and man's laws. These are the laws upon which a stable society is built. So teaches Montesquieu in the first chapter of book 1 of the Spirit of Laws, right? You don't even get past chapter 1. And this is the teaching that he's imparted. And as I said, the founders were ardent students of Montesquieu, as well as the other two authors that I talked about already. And I'm going to talk about again. We're going to start with the next one, William Blackstone. Remember that Blackstone was the English jurist, and he was a law professor in England. And he wrote his 4-volume series, the Commentaries on the Laws of England, or the Commentaries on the Common Law, they're sometimes referred to, which were published in 1765 through 1769. And these were standard textbooks, as I told you last time we talked. These were standard textbooks in every American law school up through the early part of the 20th century. Plus or minus 1910, 1920, they started getting pushed out. And we're going to talk about exactly how that happened as we go through this session. Blackstone talked very extensively about the relationship of God's law to man's law. He said, and patterning the thoughts of Montesquieu, he says, God created the universe and God impressed his principles of order on the universe. And we can never depart from those. Those principles don't come apart. They don't change. They don't move around. Without them, the world would cease to exist. They apply to every aspect of life, from the greatest elements of the environment to the least elements of the environment. He compared it, Blackstone compared this to a watchmaker. A watchmaker makes a watch at his own pleasure. How does he want it to look? How does he want it to function? How does he want the face to look? How does he want the hands to look? It's within the purview of the watchmaker to create this watch any way he wants to. And hence the hand of God creating mankind and creating the world any way he wanted to do it. But and this is Blackstone's point with respect to the operation of the watch, every single element of that watch has a purpose. Every gear, every ratchet, every hand, every dial, everything has a purpose. And this is Blackstone's comparison to the law of God. All life is controlled by God. All of culture is controlled by God, and that God's laws are fixed and invariable. And that's a Blackstone quote. They're fixed and invariable. Man is a creature, Blackstone says, and as a creature, he is subject to the laws of the Creator. All right, if he were an independent being, then he would be independent of God's laws, but he's not an independent being. All right, dependent beings draw their life from their Creator, and they have to live under the Creator's rules. That's just the way it is. The fact of the matter is, Adam and Eve sinned. Their original sin that's talked about in Genesis chapter 3 was driven by the idea that they thought they could be like God. We're going to drill into this a little bit more, but that's what Genesis chapter 3 verse 2 says. When the devil was lying to Eve, and Eve says, well, God has forbidden us to eat this fruit of the tree of the knowledge of good and evil, because if we eat this fruit, then we're going to die. And the devil says, the serpent says, you're not going to die. You will be like God. And the light bulb went off. Well, gee, if we can be like God, why don't we just eat the fruit? We don't have to worry about being subject as created beings. We can be our own creator, so to speak. And that was driving their thinking. And so Blackstone talks about the sum and substance of this law of God, and he says it's got to control all the affairs of man. And it boils down to three things: live honestly, hurt no one, give everyone his due. This concept is replete through all of Blackstone's works. And the opening clause, I mean, this is what Blackstone refers to as the law of nature. All right, he talks about the law of God constituting the law of nature. All right, and it has to control all affairs of man. And it's interesting that Jefferson in the Declaration uses that same phrase, the law of nature. In the opening paragraph, I passed out our Constitution books. If you were with us the first time, of course, we've been doing this remotely, so we haven't been passing them out. But the Constitution books, we're talking here about the Declaration of Independence. I'm on page 59 of the little book, if you have it. And this is the opening paragraph of the Declaration of Independence, where Jefferson says, when in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth separate and equal station to which the laws of nature and nature's God entitle them, a decent respect for the opinions of man require, blah, and then he goes on, et cetera, et cetera. So Jefferson makes direct reference to the laws of nature and of nature's God, which Blackstone tells us very specifically what those laws of nature and of nature's God are. We're going to get to that in just a second. And then the third individual, we talked about him already as well. And the third individual is John Locke, and he was the English philosopher and theologian, and he was the author of two books that were very, very impactful on the thinking of the founders, and that was his two treatises on civil government, and where he talks about the role of government and so forth. And here's what John Locke has to say about what this law of nature is all about. He says, the law of nature stands as an eternal rule to all men, legislators as well as others. The rules that they make for other men's actions must be conformable to the law of nature, i.e. the will of God. Laws human, that is to say laws made by humans, must be made according to the general rules of nature and without contradiction to any positive law of Scripture. Otherwise, they will be ill-made. All right, this is Locke talking. So between Montesquieu, Blackstone, and Locke, we've got this clear teaching that the law of nature is God's law. It is the law dictated by God himself. It's binding on all creatures. It applies universally across the globe. It applies to all people, to all countries, at all times. It's immutable, all right? The law of God is immutable. It doesn't change. It's consistent from generation to generation, from age to age. God's laws don't change. They are knowable. We are able as humans to know God's law by consulting his scripture and through prayer and so forth. And these laws are given unto life. And this is an important point about God's law. It's not given unto death. The law is given to us that we may live, all right? It's given unto life, not death. And it's stable. The law is stable. As I said, it's consistent, it's immutable, it's stable, and it protects life, liberty, and property, and it's superior to all other laws. Human laws can't contradict God's laws. Blackstone refers to this specifically as the common law. All right, so we've got the common law, which is a common phrase that's used in early American law throughout the discussion of the law. We've got the law of nature, which is God's law. They're one and the same thing. Common law, the law of nature, they're the same thing. And Blackstone tells us where it comes from. All right, this is from Blackstone's commentaries. He says the doctrines thus derived we call the revealed or divine law, and they are to be found only in the Holy Scriptures. Where does this law come from? God's Word. It comes from the Old and the New Testament. These principles, when revealed, are found upon comparison to be really part of the law of nature. Upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human laws should be suffered to contradict these. Man's law has to be consistent with God's law, and that is the simple fact of life that drove the thinking of the founders and drove our legal system right up through the early part of the 20th century. In Isaiah, book of Isaiah, chapter 33, Isaiah talks about God's law, starting at verse 20. He says, let's go to 21. There the Lord will be our mighty one. It will be like a place of broad rivers and streams. No galley with oars will ride them. No mighty ship will sail them. For the Lord is our judge. The Lord is our lawmaker. The Lord is our king. It is he who will save us. And so Isaiah ties this right into this concept of natural law as God being the lawgiver. And this is consistent with the Psalm of David, 19th Psalm, the Psalm of David, starting at verse 7. The law of the Lord is perfect, David says. It refreshes the soul. The statutes of the Lord are trustworthy, making wise the simple. The precepts of the Lord are right, giving joy to the heart. The commands of the Lord are radiant, giving light to the eyes. The fear of the Lord is pure, enduring forever. When he says fear, whenever we see the fear in the First Testament like this, we're talking about respect and honor for God and not this trembling fear that you would fear a tyrant. All right, so we're talking about respect here. The fear of the Lord is pure, enduring forever. The decrees of the Lord are firm, and all of them are righteous. This is the essence of the law of God, that it's given unto life that we may prosper, not unto death. And this is the essence of natural law, or the common law. It's given unto life. All right. And because God's laws are immutable, the basic laws of man have to be consistent with God's laws. They have to be based on God's laws. Likewise, the essential laws, the foundational legal system of man has to be immutable. It's got to be knowable. It's got to be understandable. All right. And so let's just talk about this concept of simple laws. It's got to be knowable. It's got to be consistent. It's got to be understandable. And certainly this malum ense concept of law is that everybody knows they can't rob a grocery store. But what happens when we drift away from that concept? Let's compare that with the Internal Revenue Code, just as an example. The internal, let's talk about consistency in the Internal Revenue. I'm not going to make a big deal out of this, but I want to talk about this for just a second. The Internal Revenue Code was changed more than 5,900 times between 2001 and 2012. 5,900 times. That doesn't even include the changes that we're talking about here in the last several years. Is that a law that's consistent? How about knowable? The Internal Revenue Code now consists of more than 4 million words. Nobody knows what this law says. Nobody knows what this law means. All right. Is it understandable? It's absolutely not understandable. All right. There was a statement by former IRS Commissioner Shirley Peterson she made a number of years ago. She said the vast majority of what we call non-compliance with the Internal Revenue Code is not non-compliance at all. It's lack of understanding. So we've got an entire population of people in trouble with the government, not because they're criminals, not because they set out to break the law, not because they deliberately and intentionally defied the legal requirements that are on them with respect to the income taxes, because they don't know what to do. All right, that is not a law that's patterned after God's laws. All right, that is not a law that's patterned after God's laws. There's no question about that. All right, the law has to be consistent, knowable, understandable. It's got to be given. And here is a clear point that has to be made here. The law has to be given to protect good and to punish what is evil. Again, this is consistent with Paul's observation in Romans 13. The civil magistrate wields the power of the sword, that is to say force, for the purposes of being a terror to evil and to protect what is good. That's what the law has to do. Now, what is the source of rights that's enjoyed by man? Where does this come from? All right, the Declaration of Independence makes clear what our source of liberty is. This is the second paragraph, again on page 59 of your little Constitution book here. We hold these truths to be self-evident, that men are created equal. They are endowed by their Creator with certain inalienable rights. Where do inalienable rights come from, friends? The tyrant? No. The legislature? No. The will of man? No. We are endowed by our Creator with inalienable rights. God is the source of rights. And this is the remarkable difference between the United States government and virtually any other government on the planet. All right? We recognize, our Constitution recognizes that our rights come from God. Our liberty comes from God. All right. Man's laws are to protect that. That's the difference. Whereas other governments believe, or others in the world believe, that governments are the source of rights, that government wields the power and the authority, and that government constitutes the essence of law. Whereas we believe that that essence comes from God. All right. This is the remarkable difference, because if the government is the source of rights, friends, then government can take those rights away. And this is what Jefferson was talking about when he talks about this word inalienable. We talked about this last time. And the idea of inalienable cannot be liened. All right, the word inalienable doesn't refer to aliens, it refers to liens, the ability to encumber your property or your assets. That's a lien. When you owe the IRS money and you don't pay, they file a lien on your property. That puts the public on notice that you owe them money. Or you get a mortgage from the bank, you sign the mortgage document that gives the the bank a lien on your property, a claim to the property. Jefferson makes it clear that God is the source of rights and they are inalienable. They cannot be liened. That is the difference between the foundations of American law and the foundations of every other system in the world, with probable exception of English common law, because Blackstone's influence there over the years. The Constitution, and so what we've got here is the Constitution was intended by the founders to be this fixed star in the legal constellation by which we would judge the legality of any statute. All right, why did ancient sailors navigate by the stars? Because the stars don't move. They're in the same place every time, depending on the time of the year. And you could move a ship from West Africa to the West Indies in the Caribbean by navigating the stars, because they don't move. All right. So this is what the Constitution was intended to be, an immutable standard for controlling the actions of government. That's what it was. Let's look at Article 6 of the United States Constitution, and that is in your little Constitution book. And it's on page 43, Article 6. It's the so-called Supremacy Clause. I'm looking at Section 2 of Article 6 on page 43 of your little book. This is the supremacy clause. The Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. The Constitution is the supreme law of the land. It has authority over everything else that is done by any legislature. All right, the federal law and state law has to be made in pursuance of the Constitution. Anything that is not made specifically in pursuance to the Constitution is invalid. Judges have to obey it. Judges are bound by it. Judges have to adhere to the Constitution as well. Now, this principle was articulated by the Supreme Court in 1803 in the case of Marbury versus Madison. This is the first Supreme Court decision that questioned or answered the question of what the authority of the judiciary was to check the power of the legislature. Right? The legislature makes the laws, the judiciary doesn't. I'm not going to give you the whole background on Marbury versus Madison. It's a lengthy fact scenario. But here's the discussion that John Marshall, the Chief Justice of the Supreme Court at the time, talked about this principle of the supremacy of the Constitution. All right, whose actions get to rule over the other? Does the legislature get to supplant the Constitution, or does the Constitution supplant the legislature? And here's what he says. The power of the legislature are defined, the powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written. We have a Constitution so that the legislature recognizes their limits. To what purpose powers are limited, and what purpose is that limitation committed to writing? If these limits may be at any time passed by those intended to be restrained. What's the point of having a Constitution if all we have to do is write around it? All right, the distinction between a government with limited and unlimited powers is abolished if those limits do not confine the persons on which they are imposed, and if the acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by any ordinary act. And then he goes on here. I'd encourage you to read it. This goes on and on about the fact that the Constitution has authority and control over the acts of the legislature. The Constitution limits those acts, and they can't surpass those limits, because otherwise, what would be the point of having a written Constitution? It would be meaningless. And he goes on to conclude that any act of the legislature that contravenes the plain language of the Constitution is invalid. The Constitution's not invalidated by the legislative act. It's the legislative act that is invalidated by the limits of the Constitution. And it's not surprising. You might not be surprised to learn that throughout Marshall's decision in Marbury versus Madison, he cites Blackstone over and over again. All right. He also cites to Alexander Hamilton in the Federalist number 78. Show of hands, everybody familiar with the Federalist Papers? If you're not, the Federalist Papers were a series of essays that were written right after the Constitution was written, but before it was adopted by the 13 colonies. And it was written by three men, James Madison, Alexander Hamilton, and John Jay. John Jay was the first Chief Justice of the United States Supreme Court, appointed by Washington. And these papers appeared in newspapers. These treatises, these essays appeared in newspapers. There were about 80 of them that appeared in newspapers throughout the colonies, and it was the argument for adopting the Constitution. And one of them, of course, was to address this concern that the federal government would have this unlimited power. And Hamilton very specifically talks about the supremacy of the Constitution over the legislature and the fact that the legislative powers were checked. And so this is Marshall's discussion in Marbury versus Madison is right along the lines of Hamilton's philosophy. So this gets us to the very heart of our limited system of government. All right, what kind of a system of government do we have? What is it that we operate under? All right, in 1787, in Philadelphia, after the Constitutional Convention was dismissed, after they had written the Constitution, and we had the signers that signed the Constitution, and now it was submitted to the colonies for ratification. There's a great old story about a lady that approached Benjamin Franklin as he was leaving, as he was walking the streets of Philadelphia, just as he left the Constitutional Convention, and she said to Franklin, "Well, doctor, what have we got here? Have we got a republic or a monarchy? So what do we have, friends? Do we have a republic? What kind of a system of government does the United States have? A republic, a theocracy, a communist system? Do we have a democracy? We all hear the word democracy all the time. Well, the United States is a democracy. What do we have?" Franklin answered the lady. He says, "A republic, if you can keep it." All right, who's heard the phrase that we are a nation of laws, not men? All hands go up. We've all heard that phrase. We are a nation of laws, not men. John Marshall used that phrase in the case of Marbury versus Madison. He says, "The government of the United States has been emphatically termed a government of laws, not men." What does this mean? All right, it means that we have a Republican form of government. Again, go back to your little Constitution book here. This is at I'm reading out of Article 4 here now. And Article 4 is on page, what page are we on here? Let me get it. Is on page 42. Article 4 is on page 42. And I'm looking at Article 4, Section 4. All right, and here's what it says. "The United States shall guarantee to every state in this union a Republican form of government," not a democracy, a Republican form of government, "and shall protect each of them against invasion and on the application of the legislature, et cetera, et cetera." All right, so we have set up, or the founders set up, a Republican form of government. What is the difference between a Republican form of government and a pure democracy? The fact of the matter is, friends, the founders rejected the idea of a pure democracy as the form of government under which we would operate. And in the Federalist Number 10, Madison talks extensively about this distinction between a Republican form of government and democracy. And he goes through it very, very thoroughly, is what the problems with democracy are. And the problems with democracy, pure democracy we're talking about now, is that what happens in society, and this is true in any society, it's true across the board, is that people are different. All right? People differ in their opinions. They differ in their intelligence. They differ in their capacities, their physical capacities, their mental capacities. Their learning level is different. Their creativity levels are different. Their ability to acquire property is different. And we've got an entire political philosophy out there right now saying that everybody should have exactly the same thing. Well, everybody can't have exactly the same thing because everybody has different personal characteristics. All right? Everybody is different. And that is just a fact of life. And this division of society, these differences in society, lead to interests of parties, special interest of parties. Madison referred to these as factions, all right? Factions. We call them today special interest groups. All right, we got this group over here that wants this protection. We want that group over there that wants that protection. This group is a large group. This group is a small group. And these factions are vying against one another for favors from government. All right, this is special interest protection that they're looking for. All right, now what Madison points out in Federalist Number 10 is that under a democracy, individual rights often get trampled at the expense of these factions. And again, because groups are of different size, if we had a situation where these groups all had the right to vote, the rights of the minority would be trampled by the majority through the pushing of their special interests. Now, I want to share with you the language of Madison. Where did it go? It's right here. The language that Madison uses, this is from Federalist Number 10 now. If you haven't read the Federalist Papers, if you got the least bit interest in how our government system really operates, you got to read the Federalist Papers. But here's Madison in Federalist Number 10. He says, we're talking about the rejection of democracy. He says, hence it is such that democracies have ever been spectacles of turbulence and contention. They have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths. All right, he says theoretical politicians who have patronized this species of government have erroneously supposed that by reducing mankind to perfect equality in their political rights, they would at the same time be perfectly equalized and assimilated in their possessions, their opinions, and their passions. Of course, that's impossible. That cannot happen. All right. So rather than adopting a democracy, a pure democracy, we adopt a republican form of government, which is based on a solid principle of law. Let me give you an example. Somebody here has the best car of all. Let's just suppose somebody has a Lamborghini. I want to imagine that somebody out there on our list here of all of our participants, you got a Lamborghini. All right. Okay. Lamborghini is a nice car. Let's have a pure democracy. Let's have a show of hands. All in favor of taking, let's just say Dave Wickland. Let's just say Dave's got the Lamborghini, and all in favor of taking Dave Wickland's Lamborghini, raise your hand. Well, you know, all we need is a majority vote, and we got Dave's Lamborghini. That's what a pure democracy is, right? Whereas a republic is based on a fixed principles of law. They're based on fixed principles of law. So we can't vote Dave's Lamborghini out of his possession. We have inalienable rights to life, liberty, and the pursuit of happiness. The pursuit of happiness was a paraphrase euphemism, if you will, for property. The capacity to acquire property, to pursue one's own calling, to pursue to pursue God's call on one's life, free of any force or imposition on that. This is what a republican form of government is, a fixed system of law. So yes, it is true that there are democratic attributes to our form of government. We vote for our legislators. We vote for certain principles that are, that find their way into the public debate, but the fixed principles of law in the Constitution, which protect life, liberty, and property, are immutable. They can't be changed. They can't be voted away. All right, this is the system of God's law, or the natural law, or common law that America was built on. Now, since the mid 20th century, early 20th century, actually, we have departed from that. Our nation has moved away from this concept of natural law. We abandoned reliance on natural law, and we adopted a legal philosophy that's referred to as legal positivism, or relativism, or what we might call positive law. So we got these two legal philosophies: natural law, positive law. Natural law is based on God's law. What is positive law based on? Based on man's whim. Positive law is man-made law. That's what it is. It rejects and abandons the idea of natural law. It pushes this idea of natural law aside. It centers on the belief that all powers are vested in man, not God, that man is the source of all power. All right? There is no objective God-given standard in the law under this positive law system. It's all about man's whim and man's law. And by extension, government then controls all authority and all power. God doesn't control it anymore, man does. And so what happens is the elites under this positive law system, the natural extension of this concept, is that man becomes God, all right? Elites that control the government under a positive law system take the place of God. They decide. God doesn't decide what's best for you. These elites in government decide what's best for you. They decide what's best for you in the areas of education, healthcare, retirement, business relations, contracts, you name it. Every area of your life becomes controlled by government elitists under a system of positive law. All right, this is the lie, friends, that seduced Adam and Eve. It's an extension of the lie that seduced Adam and Eve. All right, so go back to Genesis chapter 1. Or I'm not chapter 1, Genesis chapter 3. Genesis chapter 3. This is at verse 2, where the woman is being confronted by the serpent. It's being seduced by the serpent. He's hustling her at this point. The woman said to the serpent, we may eat from the trees in the garden, but God said, you must not eat from the fruit of the tree that is in the middle of the garden. You must not touch it or you will die. And the serpent says, you will not certainly die, the serpent said to the woman, for God knows that when you eat from it, your eyes will be opened and you will be like God, knowing good and evil. So what did she do? She ate the fruit. I want to be like God. This is the core problem with humanity. We want to be like God to a greater or lesser extent. We don't want God, the creator, to control us. We want to control ourselves. And this is the essence of original sin, and it's the whole problem with all of mankind since the fall, is we think we can be like God. All right, so this idea that the serpent said what the serpent said to Eve is the greatest lie ever told. We can't be like God. We are not the creator, we are the created. All right, to use Blackstone's analogy, the watch, how can the watch decide how the watch is going to function? Only the watch's creator, the watchman, the watchmaker can decide how that watch is going to operate. The watch can't figure it out. All right, so when we apply this concept to law, what happens is since man has evolved, all right, this concept of natural law, of positive law now, is that since man has evolved, man's not created now, man's this creature of fate, right, this creature of evolution. We've gone from the swamp to the boardroom somehow. I don't quite know how that ever happens, but that's what the theory is, that we've gone from the swamp to the boardroom, that since man has evolved, law can evolve with him. And judges and legislatures, therefore, can dictate the law. And this is how you end up, friends, with a law like New York's Reproductive Health Act, which we talked about last time we were together, which has got nothing to do with reproduction and nothing to do with health. It's all about the ability of the mother to dictate the terms of life and death over the child, as opposed to having God's law dictate life and death over the child. All right? Blackstone distinguishes between natural law and positive law. Positive law is nothing new. Positive law is nothing new. Positive law grows from the lie that was told by Satan to Eve in the garden. That's where it comes from. That's its origin right there. Blackstone distinguishes between positive law and natural law. And he says very specifically, natural law is superior to man's law. Man cannot compel violation of God's law. Man must obey laws. Let me rephrase that. Man must disobey laws inconsistent with God's law. This is what John Marshall said in Marbury versus Madison, that laws made by the legislature that are not in conformance with the Constitution are void. They have no power. Blackstone's saying the same thing. Let me share some Blackstone language with you. This is from Blackstone's commentaries. This is volume 1. It says, this law of nature, being co-equal with mankind and dictated by God himself, is of course superior in obligation to any other. It is binding over all the globe in all countries at all times. No human laws of any validity no human laws are of any validity if contrary to this. And such of them as are valid derive their force and all their authority immediately from the original. All man's laws derive their validity from God's laws. This is Blackstone's teaching. Now, there is no question about the fact that in order to maintain an ordered and peaceful society, then we have certain authority to impart positive law on that society. Jefferson made the comment. Jefferson distinguished between positive law and natural law as well in his writings. All right, and I don't have his quote right in front of me, but I'll say this. Jefferson said, law is for the living. God made the earth for the living, not the dead. And so his concept was that we have to revisit laws from time to time based on what's going on currently. But Jefferson drew the line very clearly. He said, but the legislature never has any authority to supplant basic natural law rights. All right, so this basic law that God created, we don't have any authority to supplant. So what was Jefferson talking about when he says laws are for the living, that God created the earth for the living? What he means is this. Let me give you this example. What is the biblical authority, friends, for speed limits? There isn't any. There's no verse, there's no chapter that says thou shalt not drive your car more than 50 miles an hour. It's not there. All right, so the imposition of speed limits is an act of positive law. And the imposition of speed limits is a reasonable act of the legislature to control behavior for the purposes of creating what? Good, not evil, for the purposes of protecting good, not evil. All right, you can't drive your car. We will all agree that you shouldn't drive your car 70 miles an hour down a residential street past a school. All right, we all know that. But some idiot out there is going to drive his car 70 miles an hour down a residential street past a school. So we have legislative action that's specifically intended to remind these idiots that you don't drive 70 miles an hour down a residential street past a school. And if you do, then there's going to be consequences as a result of it. That's an example of positive law that is not in violation of God's law, which Blackstone would recognize and Jefferson would recognize as a valid act of the legislature. But what happens when these acts go beyond that, contravene the Constitution, and invade individual liberty and individual rights? Those laws are invalid. All right, now where does this concept of positive law, where does that get introduced? And we're going to bring her in for a landing here at this shortly. Where did this positive law concept get introduced into American law? We know where it got introduced into culture. Got introduced into culture with the serpent's seduction of Eve. That's where it came to be. But how did it end up in American law? That's the question. If American law was grounded on God's law, which it was, and operated under God's law, which it did, where does positive law come from? The idea began in the late 1800s with a man named Christopher Columbus Langdell. And Langdell introduced this concept of positivism, positive law, when he was the dean of the Harvard Law School in 1870. He introduced what was called the case study method of learning the law, as opposed to studying Blackstone and the fixed principles of law. Then Langdell said, well, we got to be studying the decisions of judges. What are judges saying? What are judges doing? And so this case study came into being. And what happened is historical precedent and original intent and all of the foundational history of the basis for legal rulings became pushed aside. All of that became pushed aside. Blackstone's commentaries were discarded, and what happened is we got into this sort of evolutionary concept of law. A lot of the graduates of Harvard, when Langdell was in charge, went on themselves to be lawyers and judges and teachers in other law schools, and this gradually took hold. Langdell's theory of positive law, positivism, took hold, and it took hold to the point where it captured the imagination of the American left at the time, and most clearly it was seen in the writings and the philosophy of Woodrow Wilson. Of course, we all know Woodrow Wilson was president of the United States. He was the 28th president. He served as president from 1913 to 1921. We can thank Wilson for the income tax, by the way. The 13th Amendment was proposed by Wilson, ratified under his watch. And the Federal Reserve System that we have now, you can thank Wilson for that. And so, this example I gave you earlier, the worst case scenario with positive law, you can thank Woodrow Wilson for that. Wilson wrote a book called Constitutional Government of the United States that was published in 1908. And Wilson talked about how we have to view the Constitution of the United States. He acknowledged in his writings that the Constitution of the United States was grounded firmly on the concept of natural law, right? This is some of Wilson's writing. He says, it is clear that the Constitution of the United States was made under the dominion of Newtonian theory. He refers to it as Newtonian theory. The Newtonian, we're talking about Newton, the physicist, and his concepts of natural law, right, which Jefferson adopted. But Newtonian physics is natural law. That's what it is. All right, and he refers to it as such. He says, now he's going on here. This is Wilson going on. He says, you have only to read the papers of the Federalist to see this fact written on every page. They speak of checks and balances of the Constitution, to use the express idea, the simile of the organization of the universe, all right, and particularly the solar system. He goes on and on like this. And then he says, the makers of our federal Constitution read Montesquieu. There's Montesquieu, right? The makers of our federal Constitution read Montesquieu with true scientific enthusiasm. They were scientists in their way, the best of their age, those fathers of the nation. Jefferson wrote of the laws of nature and of nature's God, and they construed a government as they would have construed a solar system subject to the laws of nature. But politics, and he says that politics were thought in as mechanics, and he goes on from there. But Wilson was not a believer in natural law. He was a believer in positive law. And here's what he says about what the Constitution has to be. Listen to this now. He specifically rejects the idea of natural law. And he says the trouble with this theory of government is that government is not a machine, but a living thing, a quote unquote living thing. We've all heard this phrase. Well, maybe, let me just not digress here. Listen to this. It falls not under the theory of the universe, but in the theory of organic life. It is accountable to Darwin, not to Newton. It is modified by its environment. It's necessitated by tasks shaped to its functions. And then he goes on and on. Government is not a body of blind force. It is a body of men. A body of men, that's what it is. All right, it's highly differentiated in its functions. He goes on and on. He says, living political constitutions, this is his conclusion, living political constitutions must be Darwinian in structure and practice. Society is a living organism and must obey laws of life, not mechanics, and so forth. Friends, this is positive law at its most basic concept, right? This is what it is, all right? And so what we're saying here is that man can control all aspects of law, that we can't be married to any fixed system of law, such as, for example, God's law. That can't be it. And this has taken hold. Charles Evan Hughes was a justice of the Supreme Court, in fact, a chief justice of the Supreme Court. He served from 1930 to 1941. And he made the statement, he says, we're under a constitution, but the Constitution is what judges say it is. In other words, we can make it be anything we want because we are no longer under a fixed system of law, natural law or common law. No, we are under now positive law. So the Constitution is not going to be a fixed star in the legal Constitution. All right, it's not going to be immutable. No longer are its guarantees going to be solid and reliable from generation to generation and age to age. Rather, the law is going to fluctuate. It's going to evolve. It's going to change. Who's going to be responsible for changing it? The elites in the government, the elites in the courts. That's who's going to do it. All right, this is where legal activism comes from, this idea that judges make law. The Constitution gives no authority to for judges to make law, yet they do it all the time. And this is why our Constitution doesn't look today the way it did 150 years ago. This is why our system, our way of life is slipping away from us, and we don't even know why. And the reason why is because of this distinction between natural law and positive law, and the fact that we have rejected God's law as the foundation for our society, and we have adopted this Darwinian theory of legal evolution that the law can be whatever we want it to be whenever we want it to be that. And under such a system, all of society collapses. All of it collapses. All right, I want to give you a couple examples as we wrap this up here. I want to give you a couple of examples of how this happens. In 1962, the Supreme Court declared prayer in public schools, even voluntary, non-compulsory prayer in public schools, was deemed to be unconstitutional. All right, this was the case of Engel versus Vitale, and 1962 Supreme Court decision. In 1963, Bible reading was excluded from public schools as unconstitutional. This was the case of Abington School District versus Schempp. All right, so this Engel case, I want to talk about the Engel case for just a second. The Engel case was decided, this was the case that took prayer out of public schools, was decided with the court rejecting 170 years of American legal precedent and over 400 years of historical precedent. We took you through in the very first session, I took you through the 400 years of American history. The Engel case, the Engel court rejected all of that. Now, here's what's fascinating about the Engel case. Not one single legal precedent was cited by the court for the authority of declaring prayer in public schools unconstitutional. Not one. Not one. In the Abington case, the same thing. There was no legal precedent to support the idea that prayer could not go on in public schools. And in fact, they specifically rejected Supreme Court precedent, the Vidal versus Girard's executor case, which I talked about in the slavery issue. That was written by Justice Story. Now, in the Abington case, rather than citing legal authorities for their positions that you can't read the Bible in school, they relied on some historian. All right. Now, I talk about this in my book, Salt and Light, which I talked about last week. This is on page 39 of Salt and Light. I want to read this to you. This is what the United States Supreme Court used to reject hundreds of years of historical precedent and over 150 years of legal precedent with respect to prayer in public, Bible reading in public schools. In the Abington case, the decision of the Supreme Court turned not on legal precedent, but the expert testimony of a historian, all right, a historian, not a psychologist, not a psychiatrist, not a legal scholar, a historian by the name of Solomon Griselle. His testimony was summarized by the court as follows. If portions of the New Testament were read without explanation, they could be, and in his specific experience with children, Dr. Griselle observed that they had been psychologically harmful to the child and had caused a divisive force within the social structure of the school. All right, this is what they were afraid of. That's why you can't read the Bible in public schools. No legal authority for it. All right, the greatest example, the single greatest example of the operation of positive law comes from the United States Supreme Court case, United States versus Lee. It's a 1982 Supreme Court decision. And it is a Supreme Court decision that involved the claims of Mr. Lee, who was an old order Amish business person. All right, so he was a member of the old order Amish in Pennsylvania. And the Amish are religiously opposed to any form of public insurance and any insurance whatsoever. They rely on one another as their community, as their community to support each other. And that's what they do. Their religious principles require that the family support the family, and that's what they do. So they reject forms of public insurance, including, of course, Social Security, which is a form of public insurance. All right. And so they rejected these things on religious grounds. And the fact of the matter is that the Internal Revenue Code and the IRS procedures allow Amish people, Mennonites, certain others in that category, to remove themselves from the Social Security system. It can be done where you don't have to pay Social Security taxes. And Lee and others had done that. But what happened is in 1982, Congress passed the Tax Equity and Fiscal Responsibility Act, and it was an expansion of Social Security for the purposes of making the Social Security system solvent, which it hasn't done. But in the early part of that decade, there was great concern about Social Security system going broke, and it's still going to go broke, but that's a different discussion. And so they expanded it greatly, and they made certain aspects of the Social Security Act applicable to business people, even those business people who had withdrawn from the Social Security system because of their religious principles. And so Lee took the position that these expanded Social Security laws violated his First Amendment rights to free exercise of religion. And he ended up in court, and his case ended up in the Supreme Court. And here's what the Supreme Court said about his religious principles now. It said that based on his faith, and based on their practice and based on the nature of the tax, the court says, this is a quote, both payment and receipt of Social Security benefits is forbidden by the Amish faith. Because the payment of taxes or receipt of benefits violates Amish religious beliefs, compulsory participation, listen to this now, friends, compulsory participation in the Social Security system interferes with their free exercise rights. Now you'd say to me, well, Dan, it says right there, the Supreme Court said right there, it interferes with their rights. that should be the end of the case. And you would think that that would be the end of the case. The law interferes with their rights. They have an absolute right to their religious beliefs. The First Amendment makes it clear. That should be the end of the story. But it wasn't the end of the story. Positive law allowed the Supreme Court to introduce something into the discussion that the founders never intended and that is not written in the law. The court says the conclusion that there's a conflict between the faith, the Amish faith and the obligation imposed by Social Security is only the beginning of the inquiry. Well, wait a minute. How can it be the beginning of the inquiry? The First Amendment is clear. Congress shall make no law. All right? That is as simple as that. But the Supreme Court said, no. That's just the beginning of the inquiry. We have to go to the next step now. What's the next step? In order to get to the next step, the Supreme Court analyzed the Social Security system. And they recognized, now this is at the time. Now, of course, it's a little bit different now because we're 20 plus years down the road. The Social Security system at the time was distributing benefits of $11 billion monthly to 36 million Americans. I think there's more like 50 million Americans on Social Security now, and the benefits are going out every month, all right? And so what the court said is the court has to decide whether there's an overriding governmental interest that has to be balanced against Lee's constitutional rights. Are you kidding me? What overriding governmental interest is written into the First Amendment? There is not one. It doesn't exist. But here's what the court said. The design of the Social Security system requires support by mandatory contributions from covered employees and employers. This mandatory, listen to this now, this mandatory participation is indispensable to the fiscal vitality of the Social Security system. So what was the overriding governmental interest that needed to be balanced against Lee's constitutional rights? The overriding governmental interest is we need the money. We need the money. And that's what the Supreme Court said. This is the conclusion. This is mind-boggling to me. Religious beliefs can be, this is a quote now from the court, religious beliefs can be accommodated, but there is a point at which accommodation would radically restrict the operating latitude of the legislature. This is what positive law does. All right, here's what it means. The government can do anything it wants and your rights be damned. You don't have any rights. As long as we can claim some governmental interest, regardless of what it is, in this case, we need the money, then you don't have any rights. This is the danger of positive law, friends. This is why we reached a point in America where America doesn't look like America. It's because of positive law. This is what's happening, all right? This is what is going on here. We are degrading our culture. We're degrading our entire system of government because our system of law has gone away from being founded on God's law and grounded on principles that are immutable and everlasting and unchangeable from generation to generation to a Darwinian system of government that changes at the will of man. That's where we're at today. This is why we are in such trouble in the United States and why we have to get our arms around what the real problem is. The real problem is we have moved away from God's law to a Darwinian system of evolving law. That's it. You got me all riled up here now. I'm done. The end.